Okay, so we are going to start immediately. I have, unfortunately, Professor Beatrice Pasciuta couldn't come at the very last moment, so I'm presiding also this session. It's a pleasure for me, again, to friends and colleagues. So first, Guido Rossi. So very briefly, Guido Rossi is a full professor of medieval and modern legal history at the University of Palermo. His city of origin, where he came back after many years spent in England, il rientro dei cervelli, so called, and after being in Edinburgh for a long period. I have to be brief. Here he is going to talk about insurance, and many of us maybe recall his almost 900 pages monography on insurance in Elizabethan England. Thank you very much for being here, and I leave you the floor immediately. Thank you.
Thank you so much, Stefania. Does it work?
No.
Can you? No.
Okay.
Can you hear me?
Yeah, the other one. We don't have.
Yes. Sorry. So sorry. Thank you. Thank you so much. Thank you for your words, Stefania. It's a great privilege to be with you today, this splendid little island of San Servolo within beautiful Venice, and we owe all that and more to Professor Gialdroni, and their exciting and challenging project. So thank you, Stefania.
Thank you.
Now, briefly, I'm asked to say something on the Lex Mercatoria debate with regard to pre-modern insurance. Let me start with a short, but one of my favorite sayings from the late Timothy Ware, for many years a distinguished theologian at Oxford. He would often say, people like to hear what they already know. So let me tell you what you all know already. Very few, if any, would still believe today in the idea of a Lex Mercatoria and the way it was framed, especially from the 60s onwards, by scholars like Schmidhoff, Goldman, and the like. We have just heard much about this in the most wonderful paper by Dr. Deibel. So it's really hard to believe that today, and yet this is what we often still encounter when reading introductions to contemporary commercial law, contemporary maritime law, and especially contemporary insurance law. I say especially in insurance because here I think there is another force at work. As you all know, insurance is not a Roman law institution, and this causes a problem, as here we don't have a red thread linking ancient to modern rules, the way any proper and self-respecting private law institution is supposed to behave. So if we have an institution genuinely emerging from layers and layers of gradual historical sedimentation, as it were, in the eyes of some, at least unconsciously perhaps, we have a problem. It's a nasty problem because a non-negligible part of Europe stuck to their insurance practices, stubbornly refusing whatever little Roman law could be applied to it. So since regrettably we don't have a fifth book of Justinian's institutes devoted to commerce, we might as well think of abstract, general, universal rules on commerce. This way, I think the original sin of some commercial institutions, the fact that they are not Roman, remains, but its virulent force is neutralized, for we are still able to think of abstract rules floating around, moving across time and space until finally crystallized in the modern framework of a code. Another problem we have, if not created, at least conspicuously contributed to keeping alive ourselves, as Jake said it. Hercules learned the hard way that the best approach to kill a hydra is probably not trying to chop each and every head it sprouts from the body. Out of modesty, no doubt, we lawyers don't compare ourselves to a demigod, so we forget his lesson. In other words, writing about Lex Mercatoria in order to debunk the Lex Mercatoria is one of the best ways to ensure its enduring significance. So it's a catch we have. The difficulty, therefore, I think, is not simply to decide whether the Lex Mercatoria debate, we should continue with it or not, or whether the Lex Mercatoria existed or did not exist. Because framed in that way, the question invites an unhelpful swinging between over-systematization and over-skepticism. The real problem, I think, is more precise. How should one conceptualize a historical field in which merchants plainly share techniques, contractual solutions, and practical expectations across regions, but in which those shared practices did not crystallize into a single, fully articulated, autonomous legal system? To begin with, I think, a good antidote to avoid falling into the definitory trap is to keep in mind a self-evident, basic proposition. At its core, insurance has always been a risk-shifting mechanism. I prefer using this neutral term, mechanism, instead of others, for contract carries much legal baggage. Institution brings in much economic weight. On the one hand, merchants used the same mechanism pretty much everywhere. On the other, this mechanism had to be applied in different places, so that the legal and institutional features of those places must be taken into account to understand how the mechanism operated in practice. The confusion, I think, begins when we forget that what was used across different places was not a set of rules, it was a mechanism. The same mechanism can be adapted to fit within various heterogeneous legal and institutional settings in the way a rule simply can't. This basic difference becomes all the more significant if we consider that from a legal perspective, pre-modern Europe is a mess. We've come up with more refined expression to say the same thing. So instead of legal mess, we normally speak of legal pluralism. But it's important to keep in mind that, though more elegant, pluralism is code for mess. If we start from this simple point, I think the rest of the picture also becomes somewhat clearer. The question is no longer whether merchants shared one body of rules. The question is how the same risk-shifting mechanism was made to work across different markets. And once one puts the problem in those terms, what matters most is no longer the search for legal unity, but the way in which a common practical device was translated into different documentary, judicial, and evidentiary settings. Let me begin with the point that has always exercised a special fascination in this debate: the policy. Insurance policies from Mediterranean and later Atlantic markets are often recognizable at a glance. It's easy to spot them. Voyages are described in similar ways. The clauses seem familiar. Exclusions, contingencies, methods of valuation recur. It's very tempting, therefore, to look at the form of the instrument and conclude that the law behind it must also have been the same. But I think that conclusion asks too much of the document. Similarity of form can arise in many ways. It can come from legislation, doctrine, of course, but it can also come from repeated copying, notarial routine, professional convenience, merchant imitation, and if you like, from the habit of drafters who prefer not to abandon clauses that are already working well enough. So why change it? They are not lazy in keeping them. They need to entice underwriters. As underwriters are risking their own money, they feel reassured by finding in the document what they would expect to find. Novelties are dangerous. Insurance is a particularly good example of all this because the policy is at once central and deeply misleading. Take Genoa, for instance. Stefania's mentioned Genoa earlier, so wanted to keep with that example. The oldest maritime risk shifting devices that we know in the Western Mediterranean come from Genoa. And the extraordinary, and Genoese policies became famous precisely because of their brevity, the very, very short, their cryptic look, and the extraordinary amount of things they left unsaid. Very, very short, the shortest we have, in fact. Read on their own, they seem to contain very little, and yet they worked. Why? Because they only worked within a Genoese world of notaries, merchants, courts, and case law. In other words, the mechanism was there, but its operation depended on a whole local interpretative environment. Without that environment, the document would become opaque. This, I think, is a first serious difficulty for any strong version of the Lex Mercatoria thesis. If a Genoese policy needs Genoese practice in order to make sense, then the same text can simply be exported abroad as if it carried its own legal meaning encoded within it. And indeed, Genoese merchants exported not only policies, but also brokers, customs, and interpretative settings. This, I think, confirms the point. What troubled was not a complete body of rules. What troubled was a practical mechanism plus the expertise, the toolkit, if you like, that was needed to make it function. The contrast with Florence, for instance, is quite useful here. Florentine policies were generally clearer, more explicit, much longer, actually. And for precisely that reason, they traveled more easily. This helps explain why, for instance, in post-Reformation England, Florentine forms of policy proved more successful than the Genoese ones. You didn't need to be a specialist simply to understand what the instrument was trying to say. It's there. And yet, even here, circulation didn't produce unity. Once the Italian influence weakened and the Flemish influence increased, London began to absorb Antwerp usages as well. At some point, one finds English policies trying to follow both the old Italian customs, the customs of Lombard Street, and the usages of Antwerp. But those usages didn't always coincide. So the result was not harmony, but litigation. Underwriters objected that a given instrument reflected Antwerp more than London. This way, the very circulation of forms produced friction and then adaptation. What moved from place to place was not one law, but a repertoire, if you like, of workable solutions that had constantly to be adjusted. Something similar appears if one looks at codification. The Barcelona ordinances of 1484 were by far the most ambitious attempt in the 15th century to give insurance practice a more stable normative framework. Their influence spread wide, but not in the manner of a law radiating outward from a sovereign center. Each place that received that model adapted it selectively and made it operative through its own procedures. Naples, Messina, Burgos, Antwerp, all could draw on related materials without thereby entering into one common legal order. The spread of solutions was real, legal identity was not. This is why I think it's better to speak of standardization without centralization. Clauses were reproduced because they were useful. Once a certain wording had become familiar, every later drafter had a reason to keep it, unless there was a stronger reason to change it. The authority of the clause was cumulative rather than legislative. It came from repeated use, and that can produce a very high degree of formal convergence without resulting in legal uniformity. A mechanism can be standardized in its visible form while remaining deeply dependent on local institutions for its practical meaning. Indeed, the more one looks at policies over the long term, the more striking that point, I think, becomes. In many places, the text of the policy remains surprisingly stable for centuries. London is the obvious example. Apart from one single clause, the invocation of God, in the name of God, Amen, that drops in the 19th century. Apart from that, the form of the policy didn't change at all from the second half of the 16th century to the second decades of the 20th century. But during this very long time, the rules, the assumptions, the interpretative principles surrounding it changed profoundly. Exactly the same can be said for Spanish, Italian, and French policies between the 16th and the 18th centuries. On the surface, the instrument didn't change. Behind the surface, however, its application did change, and often in a very meaningful way. The same instrument, therefore, could conceal very different legal realities. A non-expert merchant reading a policy might think he was looking at continuity, but in practice he was facing a mechanism whose operation had been reshaped by practice and by law courts. Thank you. And that takes me to what seems to me the decisive issue: enforcement. If one really wants to know whether a common mechanism implies a common law, one has to look at what happens when things go wrong. Insurance is not simply about allocating risk in advance. It's about disagreement after the event. And at that point, the mechanism depends entirely on the institutions capable of deciding and enforcing. And here, the idea of unity becomes much harder to sustain. There was no trans-regional merchant court for insurance. There was no autonomous apparatus of coercion belonging to commerce alone. What there was, instead, was a great variety of local and supralocal courts: municipal courts, consular courts, admiralty courts, common law courts, civil law courts, and so on and so forth. Each of them has its own procedures, its own categories, and its own habits of interpretation. The same mechanism could therefore be read differently depending on the forum in which a dispute was heard. The English example is again instructive. Once insurance was fully in English hands, a struggle began over who would control its litigation: municipal courts, admiralty, or the common law courts. In the end, the common law courts won the day. That victory mattered not merely because it changed the institutional venue, but because it gradually changed the legal language through which insurance was understood. To say that insurance continued to exist is true. To say that the same mechanism was now being filtered through common law assumptions is also true. The same sort of thing, mutatis mutandis, can be said elsewhere. As courts became more sophisticated and as learned law or state law exerted stronger pressure, the practical enforcement of insurance diverged more clearly from place to place. This is also why pre-modern pluralism matters here. Merchants didn't operate against a single judicial background, and the practical handling of disputes could vary from place to place, obviously. Because of time constraints, I can but hint at this complex point. But even only hinting at it should be enough, I hope, to make one cautious about treating the mechanism as evidence of one legal order. And if enforcement already invites caution, questions of proof do so as well. Insurance deals with uncertain events, and this inevitably raises the problem how loss is to be established. It is one thing to agree in principle that a peril is covered, but it's another thing to determine in practice whether the event has been shown with sufficient certainty. Here again, the basic difficulty was widely shared, but its legal handling could vary according to context, procedure, and forum. And finishing. And this matters enormously because without some shared method of constructing fact, it's very difficult to speak of a shared legal system. One can have recurring clauses and recurring commercial expectations without having recurring legal effect. The legal construction of fact remains local. The example of presumed loss, I think, is a good one. At what point should silence count as evidence? No news. Is it evidence? When? How? How long must one wait before treating a ship as lost? Different markets and different courts answered those questions differently. Sometimes they moved in the direction of mercantile experience. Other times they didn't. A wonderful example comes again from Genoa, and you mentioned the Rota, the Genoese Rota. And in the 17th century, the 60s of the 17th century, the Genoese Rota could reason about the speed of news by excluding nighttime hours. They counted only the daytime. Why? On the basis of classical learning, basically on the basis of the panegyric by Claudianus to Honorius. The night is made for sleep, and therefore it doesn't count. That's only an example. The same mechanism is not operating inside one epistemic regime. It's operating in several. This crazy idea is to be found only in Genoa, only during those years. Then they changed, thankfully, their mind, for example. If one puts together these different levels, documentary form, circulation, enforcement, and proof, I think the overall picture becomes reasonably clear. Merchants across Europe shared a mechanism for shifting risk. They also shared many clauses, many expectations, and many techniques, but none of these required or produced a single autonomous legal order. On the contrary, the mechanism worked precisely because it was flexible enough to be translated into different settings. That was its strength. And that is also the reason why the language of the Lex Mercatoria obscures more than it clarifies. So in the end, I would prefer to say something quite simple. What circulated was not one body of rules, but a practical device. The device was portable. The law was not. The device could travel from Genoa to Florence, from Florence to London, from Barcelona to Burgos, from the Mediterranean to the Atlantic. But each time it entered a new environment, it had to be made intelligible and enforceable there. That is why similarity of clauses does not amount to unity of law. The mechanism was common. Its juridical life was plural. And this, I think, may be also the safest way to move beyond the older and stale debate. We don't need to choose between the fantasy of a universal merchant law and the opposite fantasy of complete local isolation. Insurance suggests a better path. Commerce could be highly coordinated without being governed by one autonomous legal order. What held things together was not a floating system of universal rules, but the capacity of one risk-shifting device to be received, adapted, and enforced in many different legal words. If that is right, then the lesson is perhaps not limited to insurance. More generally, pre-modern commercial law perhaps might be better understood not as the history of one system, but as a history of coordination through plurality. And if that sounds less elegant than the old formula of a Lex Mercatoria, perhaps it also sounds, to me at least, a little closer to the sources, and perhaps a little closer to reality as well. Thank you.
Okay, very good. Okay, thank you very much. In reality, we are not so late now. I don't want, because we will do the all questions at the end. So we have some time because at 1 we should go for lunch. So we have 1 hour, so it's okay. No, ok, no, don't, no, allora, lo sapevo che non dovevo dire questa cosa. No, mi ha fatto paura la cosa un po'. Okay, so now it's the turn of Professor Maria Fusaro from the University of Exeter. But in reality, she comes from Padua. She studied in Venice and then in Cambridge and then in Exeter. She ended up in Exeter, or is there something in between?
There's something in between.
There is something in between.
No one cares.
I care. Okay, so, but anyway, these are, okay, you can have an idea of the journey this way. And she's an economic historian of the modern period, focusing on trading networks with an expertise in the Venetian Republic and the Mediterranean area. And she has been part of the advisory committee of this project from the very beginning. And it's a very, for me, it's very, very important part of this project to try to establish a dialogue with other disciplines. Of course, economic history is not that far away, and of course, economic historians are interested, Maria is for sure, in the mechanism of the administration of justice. I mean, this is a matter of fact. So, and she's also the winner of 2 ERC projects. I cannot remember the name, the first one, the starting, but the consolidator is Aequitas Risk, and it's about risk management and the general average and this kind of problems, and she is going to talk about this, I mean, the issue of risk management. This is what, you can talk whatever you want in connection with the great issues we are dealing with in this conference. So thank you very much for being here, and
Thank you, Stefania. Thank you particularly for having involved me in MICOLL since its very beginning, which has given me quite a lot of intellectual fun, which is the rarest of commodities these days. But I also would like to thank, loudly in public, Albrecht. 10 years ago, he invited me to Frankfurt, the first proper legal historian that actually took any notice of my solitary rants. But in actual truth, my intellectual debt to Albrecht long predates Frankfurt. It was started to be accrued at the time of my postdoc in Oxford, when I was spending quite an unsociable amount of time on my own in the Bodleian Law Library, trying to make some sense of the discrepancy between jurisprudence and the material that I was finding in the archives. And I have to say that this article on the search of Lex Mercatoria was an incredibly reassuring piece of scholarship that still reassures me after 30 years. So thank you, Albrecht. Now comes the outsider, and it's interesting what Stefania was saying. I'm certainly not a legal historian, but in issues of intellectual identity, I find myself somewhat at a loss. And I shall briefly indulge in some autobiographical considerations because I think they're relevant to the substance of my observation. There is a wonderful quote that struck me a long time ago, and in a sense it's one of the mantras that frame the Cartesian plan of my own research. It comes from Christopher Hill, and it says, "It's time to take legal history out of the hands of the lawyers, as religious history has been taken out of the hands of the theologians, and relate both to social development." Now, I belong to the first scholarly generation that was told that interdisciplinarity was the way forward. Unlike wiser colleagues, more successful colleagues that paid lip service to this and hung tightly to their own specialist, I actually made the fatal mistake of believing it. You know, some of us are more naive than others. What am I? I'm a social and economic historian. So economic historians don't think of me as an economic historian because I'm not quantitative enough. And the reality is that the shadow of cleometry, which comes really like theology, out of the fear of death and reassured by made-up figure, linear regressions, anyone, I find legal evidence the basis and centrality of my research. I'm also the student of microhistorians, so there is something which allows you to enter into the crack between the normative and real life. And this is what intrigued me as an historian. When I see this crack, that's where I jump. And I normally write a project about it. So I was involved in 3 projects that are the basis of my considerations today, which are a bit off-piste compared to what I told Stefania, but I found yesterday's talk by Albrecht incredibly stimulating. And in fact, Stefania's original abstract sent me on a tangent, and I'm known for taking tangents. My first ERC project was called Sailing into Modernity. It analyzed maritime employment and related litigation in a comparative manner. Now, the idea was, in line with a unifying literature on Lex Mercatoria and Maritime, because of course Maritime is the mother of Mercatoria, as maritime legislation, lived in its own independent spheres, shaped by universal convention, which made it all the same around Europe, going to court in Venice, Marseille, or Genoa, as opposed to London or Amsterdam, about your own wages, should have yielded the same outcome. Oh boy, no. No way. Substantially different outcomes. This also led me to an element about the European kind of mode of handling different jurisdictional element, which then I was lucky enough that Luisa involved me in some of the activities of FEDRA. Then I moved to another alternative project, which was ConfigMed, the ERC advanced grant by Wolfgang Kaiser. And the idea of that project was to achieve a more precise and deeper understanding of the practices of intercultural trade. Anna Delem was part of that. In a constant, profoundly shaped by legal pluralism, which Guido actually calls mess, I agree, and multiple and overlapping spaces of jurisdiction. And then there was my arbitrage risk. Now, general average became one of my personal obsessions, and I think that lots of colleagues, some of them have actually confessed it openly, thought I was going completely insane in putting up a project on this. Because theoretically it had been unchanged since before Rome. Having a wonderful conversation with Joshua Getzler when I started to think about it, and he said, yeah, we teach it by just reading the bit about it in the digest. Now, GA principle of mutual protection and of redistribution between all stakeholders, stake, not share, of the cost related to the action successfully performed to save the venture, appeared unchanged. And in real practice, again, monumental differences. Like insurances, in a sense, what Guido was saying works for GA as well. One principle, a multitude of difference in its application. Enforcement, apportioning. Now, in the absence of the conference, there seems to be a desire to get into dialogue with this stupendous volume that came out a few years ago by Chris Wickham about the commercial revolution. Now, I'll get back to this in a bit more detail. Let me start by saying that it's a masterpiece. It's one of those fantastic works that will keep us debating for the next 20 years. That's the Aristotelian major premises. let's get down to the debate about Lex Mercatoria here. He uses the example of general average as one of Lex Mercatoria. He mentions the Lex Rodia de Iactu, fine. He says, pre-Roman law recognized by early emperors, I'm quoting, to late 8th century Byzantine Rhodian sea law and the Kitab Acriatus to Fun of the early 10th to the Pisan Constitutum Usu of the 12th. He says the only difference, it's all the same, but the only difference is that, I quote, between them is that the Roman and Roman influence Pisan law. When referring to those market prices, assume that they are those of the port of arrival, whereas Islamic jurists, even if with some disagreements, tend to argue that they should be those of the port of departure. Oh boy, this is not a small difference, folks. This is fundamental for the economic functioning of the enterprise. First problem is that he implies a similarity, an overlapping between the Lex Rodia de Iactu and the Rhodian sea law. I prefer to call it the pseudo-Rhodian compilation because it took me quite a while to figure out that they were different, but boy, different they are. Different they are because the weight of the community of risk implied by both is substantially larger in the pseudo-Rhodian, to the point of creating a form of proto-mutual insurance. In short, the rules of the pseudo-Rhodian in the nomos, which is what is applied here in Venice and in most of the Adriatic Sea, there's this wonderful book by Guido Bonolis that to me is just like a lighting shine of early 20th century Italian legal scholarship. The man, I wish I knew him, admit the option of this shared contribution in all fortuitous accidents where there is no master liability, an old friend of Guido. That's a completely different way of conceiving of economic action. That's a completely different way of conceiving who shares risk. Because you know what? Economic activity is about who bears the risk of commercial enterprise, who pays the price, and how you define the pool is fundamental. It's possible. One, two, or three only questions. Okay. Now, all these projects are transnational because they were discussing transnational issues, and so this let me shy away. Commercial revolution and Lex Mercatoria. Stefania asked us to reflect on whether these concepts are still offering something to us in terms of stimulating further research. Now, let me be provocative. I play the role of the economic historian. Of course, I'm not really one, but then again, there you have it, interdisciplinarity for you. Jake described Wickham, donkey in the boat, then the boat. I was going to say donkey in the boot, but hey, a highly comprehensive and erudite reassessment of the medieval commercial revolution. That's true. But it's something else and something a lot bigger. It is the latest salvo in a long-standing debate amongst economic historians about the precise moment of the European economic takeoff, and substantially about which sector of the economy was the first one to allow the economic takeoff. Because economic history as a discipline has got really one question, alas. What started modern economic growth? That's the Holy Grail. So, was it in the 9th or in the 12th century? Was the beginning urban or rural? Was it about agricultural output or its exchange? What is it about exchange on the short range, on the medium range, or on the long range? And if you're talking about exchange, is it about high value or low high volume? Now, higher profits foster capital accumulation. Hence the stress of long distance, of all the center to right wing political thinkers, okay? The problem, one of the things that Chris is trying to fight is The feudal world, the feudal economy is under-theorized. The short range is fundamentally relevant, and without the short range properly functioning, you cannot have a long range. And then he elegantly stops in 1180, on which more anon. So, what we need to keep in mind when dealing with economic history, with all economic history, is that the intellectual roots are English and then American. The problem was the origin of the Industrial Revolution, hence modern economic growth. That's what Adam Smith was talking about, David Ricardo, Karl Marx. I could go on, I won't. Few giants in the room are enough. These individuals profoundly embedded in the political, economic, and social realities of the British Empire. Then the Americans took up. The wonderful Norman Grass, NSB, took me ages to figure out it was Norman. Roberto Lopez, Raymond de Roover, and the way in which the US ruling class was raised in the hallowed classroom of the Harvard Business School, obsessing with the historical precedent of the economic tycoon as a ruler, folks. Why do they worship the Medici? For that reason. They all found the neutral Republican model of Venice acceptable only when Frederick Lane, in a purely neoliberal manner, promoted the importance of the military element in supporting economic activities, something mentioned by Albrecht yesterday and something mentioned by Anya in the document for the March workshop. Yes? That is when Venice becomes kosher. Oh yes, Venice is a bit odd, but you know, they also invested in the first permanent navy, which makes it relevant for a word power. Okay? Wickham posits instead a Marxian, not Marxist, he's a Marxist, nothing wrong with that, by the way. Marxian because the focus is not so much on labor, but on capital raising. And he's profoundly interdisciplinary because he takes archaeology seriously in that book. Although archaeologists are a bit objectioning about that, but that's another story. So he puts the stress on the demographic element. He's not questioning the commercial revolution, really. All I want to remind you with this is that the parameters of economic history are profoundly political, and they have been shaped by the Anglo-American experience in a way which is very different from that of legal history or of jurisprudence, who are substantially more autonomous towards the Anglo-lexic paradigm. Now, Wickham analysis contests really Lopez's argument that the commercial revolution starts in the 10th century and the pivot starts in Italy. What he says is that this has become a self-replicating mythology. Yes, it has, because the entirety of 19th and 20th century Italian economic and political history was focusing on the fantastic Italian conquering merchant. We were not a state, but for 3 times, we can say it now, we were at the top of the economic pyramid by wonderful linear regression GDP calculations. Roman Empire, 13th century, and now G7. For a country without a political unit, for a country in problems of identity, which are monumental, the success of the medieval conquering merchants became an industry. Yes, that doesn't mean that it's not true. It just means that it became also an element of propaganda. But we are in Venice, and I'm using far too much time. So let me make some Venetian consideration and finish, in a sense, although it will be a long end, so bear with me. Venice's idiosyncratic legal system has effectively restricted its comparison. I have written pages on it, my head is on the guillotine already, you just need to let the switch go. For example, the long-standing debate present in economic history and in commercial law history about the level of autonomy of merchants from the political sphere is to be declined rather differently here throughout this period. It's a problem, but not quite the same as, let's say, in Tudor England. The turn of the 12th century, as in the moment between the end of the 12th and the beginning of the 13th century, which Albrecht mentioned yesterday, is crucial, also because of the Bologna School of Law Foundation, is the pivoting point. And it's interesting that if you read Wickham carefully, that's what he says really, or implies, throughout his 900 pages. And in fact, I have to agree with Harold Berman, which is very rare, because, and I'm quoting, the rise of canon law since the 12th is an important element. Now, in Venice, a system that was, rejecting the Roman law heritage. Now, everyone did reject in the Roman law heritage. No one says, oh yes, we learned it from Rome. The difference in Venice is that they actually truly did not apply an awful lot of it, openly rejected elements in ways in which other rejectors could not dream. And this moment between the end of the 12th and beginning of the 13th century is where Venice has fundamental changes in the legal framework underpinning the state and its economic activities. Now, my first encounter with the legal mindset, as always with young minds, was formative. It was Lawrence Friedman. In a sense, I'm a Friedman babe, the legal system in the social sciences. So institutional reform, I'm convinced, follow social developments. And it's at the end of the 12th century that Venice divides the original Curia Ducis into 12 curia, although we have material, documentary evidence only for 6. Proprio esaminador, petizione, mobile, procurator, and forestiere. All first instance civil tribunal with first instance jurisdiction, with civil jurisdiction, okay? Immediately afterwards, there's the publication of the statutes in Venice, okay? 1242. I've argued somewhere else that this is a political response to two separate and connected elements. The expansion of Venetian economic activities onto the mainland, which needs to respond to an issue with real estate ownership that was not there before, and frankly, the Fourth Crusade, which is, how can I put it, possibly the apex of Venetian power at that point. And what type of cases end up in the court of the Forestiere, where I have wasted my entire life? Although, to be honest, it was a court still with the original seals of the Republic, which all of us archive rats need to admit that it's a pretty sexy way of wasting one's youth, if you're such way inclined. Summary procedure in Venice is given to all commercial cases. Boom, boom. Like everywhere else, thank you very much. I'll get back to this. But not to foreigners. Thank you very much. So the whole argument of the connection with the Clementina Sepe, with the fact that, you need to protect the weak, hence sine strepito figura iudici, does not work here. Because the conception of the Venetian legislator and the Venetian economic actor is that summary procedure is a privilege. I'll make your business go fast. And in fact, these are the only 6 proper courts in Venice. Everything else is a magistracy that has also a judicial element. It's the only one in which statute, the first point of reference, is not the usage of the court, but bilateral treaties. The foreigner is not treated weak as the poor, the widow, the orphan, as per Graziano's. The foreigner is weak only when we have no interest of dealing with him. The foreigner is strong because we want full reciprocity, because we are conquering. We are the economic system, as Jay was saying. So, free trade, when proposed by the British Empire, is not exactly free trade for everyone. We're the biggest, we've got the hegemony, so we like freedom everywhere. And it's the same mentality in Venice. What intrigues me terribly about one of the things that Albrecht said yesterday, and now I'm going off this, but I'm also going towards the end, is the bit when you mentioned canon law, Albrecht. I'm quoting you. does contain some rules concerning commercial law, namely against usury and in favor of unchartered contracts, back then and down. But this connection, I think, with the Janus figure of summary procedure, on the one hand to protect the weak and on the other to actually facilitate commerce, is, and this is in line, I'm intrigued by what Stefania was saying this morning, what is summary procedure? It's a massive umbrella term that covers all manners of varieties, and frankly, to my knowledge, we're not fully aware, so let's dive into that. Let's dive into that also because of what Albrecht was telling us yesterday about, in fact, published a lot about, the Hanseatic laws being mostly procedural. About this bloody Lex Mercatoria and the little red book of Bristol being procedural, okay? So the mobility of merchants, yes, makes them foreigners, so it might make them weak, but it also depends. It might make them even super strong. So I agree partially with Simona Cerruti's argument that the merchant is weak because its mobility denies him the social capital of being able to harness the number of testimonies and writings and writs required by the formal procedure. But there's also this other element. And this other element is that we should free ourselves from this Anglo-lexic dependency. Okay? Let me dive even deeper and be even more controversial about the Anglo-lexic dependency. I'm quoting again from Albrecht yesterday. He's talking about the little red book. An interesting contrast emerges between ordinary common law proceedings and those in commercial matters, because the treatise highlights the points where it considers ordinary proceedings unsuitable when it comes to trade and commerce, end quote. Ha-ha, it's frozen. Now, the legal origin economist, back to Harvard Business School in case you're wondering, located the legal foundation of modern capitalism in common law. These economists have made a sustained effort to show that common law lends itself better to economic growth because the common law tradition is supposedly most protective of property rights against the dangers of state predation. So, in truth, what it does is that it guarantees, in my view, it reinforces the permanent nature of some feudal property rights, which speeds up capital accumulation at the top of the pyramid and substantially weakening the protection at the bottom. The end result of this, and I'm speaking really in general terms, is Thomas Piketty's analysis about the contemporary misbalance of the Anglo-American variety of so far winning capitalism now crumbling, in which the divergence between the two elements of society will become untenable until the bottom will kill us all and they will be right. A 16th century political issue became universal, okay? The problem was how to free maritime trade, thanks to the fight to the Admiralty, from the shackles of common law, because unlike 19th century and new institutional economists, 16th century English entrepreneur knew that it didn't work. So let's create this alternative category. Is there a Lex Mercatoria? I don't think so. But what I agree with is what Luisa Brunori wrote some time ago. There is a shared mercantile culture where customary law, notarial practices, and institutional adaptation intertwined. And notarial practices is got to be our field of play, because notarial documentation is where jurisprudence meets real life. It's the place of contact. After that meeting 10 years ago, Stefania co-edited this volume that she was mentioning earlier on this morning, Migrating Words, Migrating Merchants, Migrating Laws. And in its acknowledgement, Stefania thanked all contributors, I'm quoting Stefania here, who dared to cross the boundaries, the temporal ones, the geographic one, and especially the academic ones. Our common efforts would be rewarded if this volume inspired new interdisciplinary research on trade and merchants. their languages and their law, a subject of utter importance in a world which seems to lapse back into narrow-minded nationalism. She wrote that 10 years ago. I don't think I need to remind anyone how worse things have gone since then. Interdisciplinarity leads to epistemic loneliness. Certainly for me. Stefania opened a door to mitigate this loneliness. And I'd like to conclude with a side note. When I was jotting down my notes last week, I Googled a reference. I needed a reference. I couldn't be bothered looking at my notes, so I Googled it. And as you know, when you Google something, now first thing you get the horrendous AI summary, yes? My search had the word like Mercatoria in it because that was the title of the piece. I was looking for the reference. And the AI summary said as follows, and I quote, Lex Mercatoria, far from a universal code, is how it started. Even AI got it. Thank you.
Okay, so thank you, Maria, for this wonderful, really overview, and I just open to discussion, and volevo dire che come chair mi permetto di ammettere anche l'italiano, visto che mi sembra che insomma il 90% almeno dei presenti, se non di più, comunque lo capisce l'italiano, quindi insomma sentitevi liberi, usiamo queste due lingue per il dibattito. Abbiamo mezz'ora, quindi naturalmente anche domande per Rossi, che insomma anche ci ha aperto a questo mondo dell'assicurazione molto molto importante, interessante, e questa dimensione anche europea, il caso genovese, però la sua expertise sull'Inghilterra insomma ci dà anche una visione molto ampia, quindi penso che ci siano tante domande, io ne ho alcune, però lascio a voi. Ecco Luisa Brunori, che è stata chiamata in causa, citata appena, prego.
Vedo l'italiano?
Sì, va bene, dai.
Però il microfono, se no non la sentono online.
Sì. Dov'è? Questo. Attenzione che stia.
Grazie mille, ho tantissime domande, ma immagino tutti le abbiano, quindi comincio con una per Guido. Tu hai usato una formula molto intrigante, hai parlato di standardization without centralization.
Ce l'abbiamo tutti,
È piaciuta a tutti, a me in particolare, come vedrete oggi pomeriggio. Potresti precisare che cosa intendi con questa standardization without centralization? Perché la trovo molto interessante. Allora, già che sono qui, approfitto per chiedere una cosa a Maria. Hai detto che l'ex Maritime è la madre della ex Mercatoria. Siamo veramente sicuri?
Answers in Italian or English? Maybe
I think
it's better for English for
yeah, okay, so
everybody.
you can recap a little bit the question.
Sorry, just in case.
Yeah.
So the question is, how on earth did I speak about standardization without centralization? What the hell do you mean? Good question. Thank you. The point is, very briefly, you find the same clauses, more or less the same clauses, in different languages across time and space, basically. The meaning is not identical because you have to apply it in completely different contexts, which accumulate experience, case law, and so on and so forth. And that's one part of the story. The other part of the story, and that is what Maria was saying a moment ago in a wonderful paper, okay, then if they are so different, or if they can be so different, the moment you apply them, you translate them into practice, then why do they circulate in a standard way across time and space in particular? And here, notaries, I think, really played a crucial role. If not notaries, when you don't have notaries dealing with this instrument, brokers. And so there is the way this mechanism becomes is explained in a series of standard, I would say, clauses. You can also say, well, rules, but rules can be misleading because they are the device and the way it operates in practice, and I wanted to leave that part outside. The way these clauses are traveling is because they are standards. And the reason for this standardization, I think, has a lot to do with repetition and trust. You don't trust something you haven't seen before. You don't want to risk your money with something you haven't seen and tried and heard of before. So that helps. And often, but notaries as well don't like too much changes. Brokers especially, because they have to entice people while maintaining their reputation. So there is an element leading to, looking for a better synonym of standardization, an element pointing to continuity.
Universality.
Universality. No, AI says no. So it's all. I'm not sure. Maybe I've muddled my explanation more than I've clarified. Does it make any sense? Thank you.
And no, one moment. It's
super quickly.
Yeah.
Is it a matter of lex Mercatoria? That's what a vast amount of the literature says. There is the historical literature, the non-legal one, certainly says that constantly. Because if you do like a statistical analysis of studies of maritime history, the vast majority is Anglo-American in subject and in topic, because it's so embedded in sort of national identity that it's a monumentally large field. And their assumption is that there is such thing as admiralty law. My next project, if I live enough to write it down and get the money, is precisely to demolish this shibboleth, because I'm not starting there. But they all say that, because the laws of the sea are such a common element, even more so than they do in the Lex Mercatoria. I mean, this is one of the points Albrecht was making as well in the sort of handbook of maritime history. So it's repeated, it's never justified, it's like a mantra, and everyone says it, quoting someone that has said it before, but no one actually quotes any sources about that. So it's apotropaic.
Yeah, okay, now, so we have, I think first Albert Cordes and then Raffaele Volante, so please, okay, just, please.
First, I would like to answer a question which was not asked to me, and that is your question, Rita. I wrote a paper where I tried to prove that there is a certain amount of consolidation and international approach during the 14th century, but the 13th century we find maritime laws which are so clearly and distinctly different that there is no way that this could add up to a common maritime law, not in the beginning, not where it comes from. Then maybe later when the international trade began. Now I have two questions to each of you, one for each. And the first, Guido, I really only ask because I want to be able to mention the name of Karin Nielsen von Struck, who was my predecessor in Centro and also my academic advisor back in Freiburg. in the 80s, as you know, she wrote a big book about the Venice, history of Venice sea insurance, and that was very influential for me because she drew all the legal doctrine she found out from the contracts. So that was a very interesting approach where at the very first stage, lawyers, legal historians started not only looking at law records and proceedings of tribunals and laws, but at business practice. My question, some of what you told us about Genoa seems similar, and I would like to ask you to compare the Genoan and the Venetian aspect of sea insurance. And if I may, there is one question for Maria in regard to interdisciplinarity and the outcome if different people with a different background look at the same things. And I've got two examples. One is we had in Frankfurt a big project which was about conflicts. It was actually a translation from the French word résolution des conflits. And then at one point, one wise man, it was Alain Reifens, said, well, when the courts have spoken, that does not mean that the conflict is resolved. Not at all. Conflict will go on. And so actually what we regarded as conflict resolution was maybe conflict management or something like that. And afterwards, conflict might go on or might not. And so apparently when you look at the same phenomenon from these different points of view, the result is different. And I want to ask you about a different phenomenon that is the summary, quick, apparently, it's like a mantra, it's repeated all the time, the quick decisions of mercantile courts and the interest of merchants to have quick answers. And there is evidence there, the pipe-ordered cars, and the rules that conflicts have to be settled in 3 days or 7 days or something. But in reality, I'm not convinced, because there are two parties, and the one who's going to win, they are interested in a quick resolution. And the other part, we see that they are losing, they are not interested at all. They would like to drag on and to keep the argument going and maybe get away as quick as possible and maybe settle at a later stage. So what is your take on quick resolution of maritime, of commercial conflicts?
Thank you very much, Albrecht. I don't have an hour to bore you to death, so just in 30 seconds, difference between Genoese and Venetian insurance practice across time. Of course, many, obviously, because they are different markets, different centers, and various geopolitical, institutional considerations. But just one, a legal difference, which I think is useful because it's emblematic in many ways of other places. Roman law. Venice is not part of Europe. It does not behave the way every other place, from the point of view of an Italian, is supposed to behave. The way Roman law is applied in Venice doesn't work the way we should like to find it applied. Genoa is more educated. It behaves better. So progressively you find this difference in the way the law is applied, no matter what statutes might say. Still, the influence of Roman law in the way the statutes are read and applied can be significant. To what extent it's really significant, that's another big problem, but then that is for some other time. But I think one key difference is this, and this difference is not just between Genoa and Venice, it's between any other Mediterranean, at least, market, insurance market, and Venice, and not just insurance market, I would say, and that is Roman law. It's not that Venice doesn't use at all Roman law, but they have a friendly, distant relation, and they keep it across time.
I'll start by finishing answering Guido's point. So, I have spent a couple of decades trying to normalize Venice. It is a monumental failure of my part. Whenever I think I've normalized it, something else comes, both from the terms of the economic pathway of economic growth, the economic path of economic crisis. I personally, not being a neoliberal, think it's far more interesting to study crisis, so collapse than growth, but that's my insanity. The biggest difference is that Venice was incredibly restrictive in allowing insurance here, really restrictive, only if Venetian experts had evaluated the ship and cargo you could do it. So there's a bit less of that speculative element that the Venetian traditionally accused the Genoese of having. That is correct, actually. And also, it was so wide, the application of averages in Venice, in line with the pseudo-Rhodian, that Venice insurance really is always free of averages. And because average covers so much, Venetian insurance in the end practically covers only total loss. That is the easiest difference. Summary procedure. Now, I mean, the people out there are fantastic because some of them in certain market towns requires the resolution within the day before sunset. Now, that's why I was saying earlier that I'm fully supporting the point that was made by Stefania this morning, that we need to provide, to make up a project that actually starts to provide some proper definition of this summary procedure element. I have worked on cases all my life that theoretically were handled with summary procedure. Now, therefore, there are no archival sources for that. Thank you very much. How have I managed to spend successfully so many years working on these cases and writing books about it? Because they go to appeal, because they last for millennia, because they leave monumental trails in the notarial and in the intermediate courts. Going back to a point made this morning about arbitration. The arbitration More Veneto, one of the mythological shibboleth, unappealable. Yeah, right. It's unappealable to a normal court, but it's appealable to the signoria, and it's constantly appealed to the signoria. There's a wonderful book now, 30 years old. One of the authors was Andrea Mozzato, wonderful scholar that then decided scholarship was not for him and became a physician, and rightly so, that explained this in the dirty details in the archive. So no, it's not fast. It's occasionally fast. But when it's truly fast, we have no documentary evidence about it. So on the basis of what I found because of the appeals, which are notoriously not fast, and about the fact that there are all these trails of giving power of attorney. I, Mario Fusaro, need to leave Venice because I have business to do in Rouen. Hence I leave power of attorney to Stefano Gialdroni, who will take care of the summary case procedure that is happening at the same time. So no, it wasn't fast. But, you know, it doesn't matter, it's perception.
No, la mia era solo, io ho apprezzato entrambe le relazioni e mi era venuta in mente sostanzialmente non tanto una domanda quanto una suggestione. E cioè, stiamo rifiutando, non è il caso effettivamente di riportare un po' nelle nostre analisi un po' di metodologia quantitativa, ma mi spiego meglio. A quale metodologia quantitativa mi riferisco? Stiamo parlando oramai da molto tempo della specialità della lex Mercatoria rispetto ad altri strati normativi. Il problema però, secondo me, dovrebbe essere anche misurato sul concreto delle singole controversie che la lex Mercatoria era chiamata, diciamo così, a definire. Dico definire perché alla fine, quando parliamo di lex, parliamo di una procedura che deve dare per l'appunto una certezza, che deve dare in mano a una parte che vince un titolo con cui poter avere ciò che ha diritto, quindi un qualcosa di definitivo, di non più discutibile. Mi spiego con un esempio. Prendiamo un esempio teorico, diciamo così, di controversia fra mercanti. Promessa di acquisto di una determinata merce e il promittente venditore si presenta con una merce di qualità inferiore a quella che è stata promessa. La possibilità di definire un giudizio di questo tipo non sono infinite e non entrano neanche un insieme di centinaia di soluzioni possibili, sono poche. Risoluzione del contratto, riduzione del prezzo, condanna a fornire, procurandosela da un terzo, magari a un prezzo molto maggiore, la merce che si è effettivamente promesso di vendere. Non dovremmo effettivamente misurare la specialità della lex Mercatoria, da qui effettivamente l'attenzione ai casi specifici rispetto ad altri stati normativi, sulle soluzioni che sono state prese per disciplinare un singolo caso concreto. Rispetto a questo poi possiamo fare delle altre considerazioni. Rispetto a questo possiamo poi, per esempio, interrogarci sul fatto che Venezia avesse una legislazione molto restrittiva sull'assicurazione, e assicurazione significa tante altre cose. Assicurazione significa leva finanziaria, significa possibilità di creare dei capitali virtuali che non hanno nessuna rispondenza poi nell'economia reale e creare per l'appunto quelle che normalmente oggi si chiamano bolle finanziarie o crack o cose di questo tipo. Io volevo semplicemente dai relatori una suggestione, una risposta a questa che potrebbe essere semplicemente una suggestione. Non c'è ancora spazio per un'analisi quantitativa delle soluzioni possibili.
Ladies first?
No, ladies first, of course.
Old hearts first. We don't have the sources. So, and I have an inordinate amount of respect for quantitative analysis. I wish that in the areas that I work on, I was in a position to provide figures, which of course would not be exact, but at least would provide an idea of scale. So let me stay close to home, so across this bacino. The major court that has jurisdiction over mercantile cases, but Venice, again peculiar, has got the most hybrid, how can I put it, incestuous cross-mingling of ratio personarum and ratio materiae that you can possibly imagine. So just distinguishing that. But we have the consoli dei mercanti. That is strictly what would be defined as a mercantile court along the lines of the one that Stefania was discussing this morning. We do not have any evidence surviving before the 1750s. And why? Because the Austrians arrived, found all this amount of paperwork and said, for God's sake, who needs this stuff? And so an awful lot of material was simply bulked. Let me play devil's advocate. Even if the Austrian had not culled it, and none of us would have written anything if all the material that the Republic produced had survived, we wouldn't have it because the summary justice procedure meant that there are no real, even registers of judgments as such. The Giudice del Forestier, the one I was mentioning, is spending my life, okay? It's ratio personarum. It's foreigners as defendant. Now, there's a wonderful 17th century definition by the wonderful Filippo Nani about the Forestier. He's describing the cases that involve foreigners in his manual of civil procedure that I'm sure many of you know. And I'm quoting, controversies regarding commercial companies, their management and dissolution, deeds between individuals, execution of those, and pacts between individuals. This is not a court with a ratio materia on trade, but guess what? Is this anything but trade with foreigners? Okay, the court is established in 1198. I have the final judgments, which is really a notatorio, it's a very specific Venetian type of source. It's kind of a summary of what went on, only from the 1560s, with massive lacunae. So, could someone do a sampling of a few years for a few of these courts? If you take into account vast majority, certainly you cannot do it in Genoa, because the state of the archive in Genoa, the absence of the state in the Genoese Republic is overbearing. But I don't think we'd come to anything that makes sense until we get to the 18th century. Could we do quantitative studies comparative on the 18th century? Yes. However, in my limited experience, you have two moments when specific courts dealing with commercial matters are created. The first one is the medieval wave, the Rivoluzione Commerciale one, 12, 13. And then you have a late 18th century wave, which is the one, for example, that has been studied for an awful lot of German realities, has been studied for Valencia, has been studied by Simona Cerruti for Turin, which are still merchant courts, but completely different in their essence from their medieval antecedents. For those, for some of them, we do have enough documentary evidence that would allow, should one wish, statistical analysis. For the Middle Ages, which is the really interesting period qualitatively, I don't think we do. If someone knows about the possibility, let me know. I'll kiss this person on the forehead and try to get money so that this analysis is done. Thank you.
And Guido?
Very shortly, just to add.
Come vuoi?
Okay.
No,
Yeah, very shortly. Just, you're right. Absolutely right. There's only the problem with it. We should do that. It doesn't often. Well, it doesn't always work. Now, this is probably an excuse which I'm using, because if it doesn't always work, it often does. So yes, you're right. And the reason that the excuse, the sort of the defense, which is a lame defense, because it's not real. I mean, it's not that it's not a universal defense. So you're right. Is one, the kind of transaction. So in your example, yes, it should be straightforward. Other fields within commercial law are really a nightmare of possible combinations. I can historically, bills of exchange, we have here great experts on the field, led to an enormous amount of litigation and different solutions and expertise by merchants, precisely because you can have such a combination of possible varieties, possible situations, possible scenarios, which really make it difficult to say the rule is this. Second, even in more straightforward, in simple cases, things can be so difficult as to make a quantitative analysis more difficult. There's a wonderful example by Amalia Kessler, middle or slightly later, more or less middle, let's say 18th century, near Paris, a few kilometers from Paris. You buy some I can't remember what it was, grain or some other cereals, and the norm applies in a completely different way from the way it applies in Paris. So you have to, if you go with the miller, then the rule is one. If you don't go there with the miller, if you don't buy the grain with the miller but bring it directly to him, the rule is the opposite. And So we can work on quantitative analysis for very specific centers. Does it mean then that the rule can be, or our findings can be extended, maybe sometimes not even 25 kilometers? Last problem last of the main problems, even in places where notaries flourished even more than the only place where notaries flourished even more than Italy is probably parts of Spain, where you can't record that you're giving a candy to a child without going through a notary. Even there, you find hundreds and hundreds of arbitrations, many, actually thousands of them, but you don't find what happened. You don't find who won. In order to find it out, you should go to reconstruct the whole thing, hoping that the party that lost appealed against it, but then you have to go to completely different registers. So yes, it's possible, but it would require an army of people or making everything digitized and so accessible. So still, these are excuses, but you're right, it should also be more quantitative. We should.
You mentioned, I think, or underlined a very important division by our regardings, the time. So looking of sources from the Middle Age and sources from the 16th, 17th century.
Mostly 80, yeah.
Mostly 80. So I think that's a very important observation we should think always about. And coming back to our topic, the summarized process, at the first glance, I thought, yes, we also can submit this observation under your comment that the jurisdiction of the summarized process is not for foreigners. But I have two observations which differs to this observation. The first is from Frankfurt. It's a privilege from 1344. And this privileges not only the citizens, the merchants, but also the foreigners. So the sovereignty of the city stood to benefit from protecting the foreigners which were in trade with the citizens as well. So I was wondering, and there were two possibilities, by offering to foreigners or by obliging them by the sovereignty of a city, for example. Also, similar observations we can make for Nuremberg. So my question is now, did you make the same observations about the foreigners? Because at the first you said foreigners are of this protection, of these privileges.
Well, I apologize because I clearly didn't explain it myself clearly. It's both. So it is normally offered to foreigners. In the vast majority of places where there are commercial courts, I'm talking about the earlier group, the sort of medieval groups. And in the vast majority of places where there are courts for foreigners, which are rare, it is Venice that uses it not as a compensation for social weakness, but as a privilege to incentivize or de-incentivize the presence of certain foreigners or not. So, let's put it like that. Armenian merchants, of which Venice was rather keen to have, could access summary procedure within the first year. The Jews could access summary procedure, not within the first year because they were allocated because of that's personage to the Catalan, but they could. The English couldn't, and they would not be able to do it until 1698, which is 500 years after the establishment of the court. than the last one of the foreigners to be allowed. So it's, when I was talking about the Janus nature of summary procedure, is that we do have this tradition that comes from common law, which is let's protect the weak. Mercatores are weak. Argument of Cerutti, they're weak because they don't have the social network and protection that allows them to function better within a full, Roman proper procedural trial. And there's the Venetian weaponization of summary procedure. Okay, we're gonna inveigle you into a never-ending amount of litigation so that you really realize that this is not a place for you to come and meddle into business with us as a disincentive. And this double nature, I think, is something that should be investigated. About the chronology, I'm answering a question you didn't ask me, but which pertains to our conversation last night. There, in my view, these two periods of explosions of commercial law are very substantially distinct. That's why the project you want to do about the long-term analysis of the moratorium from the Middle Ages to the 19th century becomes crucial, because you do have a single institution, emanation of a single political power that deals with how to negotiate, manage issues of bankruptcy over a comparable regional area, over incredibly different chronological moments and evenementiel. So, the thing you were telling me last night, there's a peak of this during the 30 Years' War, no surprise. The question is, do we have the same during the War of Spanish Succession, which implies some of these financial elements too? Do we have the same, in other moments of crisis? How reflective the authority of granting moratorium of the emperor is to the general economic background, to the bubbles that happen around Europe. So your project is super needed precisely because it provides a point of unity of archival and documentary and political authority across the centuries, which is very rare. Have I answered?
Allora, insomma, ovviamente è tempo forse di concludere, nel senso che sono veramente entusiasta di questo inizio di conferenza, mi sembra che ci sia stato molto interesse, un dibattito vivace, siamo rientrati nei tempi incredibilmente, quindi adesso appunto il pranzo è sempre nella stessa sala dove abbiamo fatto il coffee break, quindi questa sala Basaglia. Riprendiamo, sì, vabbè, qui si parla di manicomi, eccetera, un giusto tributo, bellissimo. E ci rivediamo alle 14:30. Volevo ricordarvi di firmare il foglio firma se non l'avete fatto, ve lo ricorderò come un mantra nei prossimi giorni, quindi abituatevi all'idea, e per chi non l'avesse fatto c'è lo zainetto con i gadget, quindi prendetelo, tutte le persone che sono qui presenti lo possono prendere tranquillamente e diciamo unirsi a noi anche a pranzo, va bene? Ci vediamo alle 14:30.